everyone. Welcome. My name is Carolyn Griffin. I'm Director of Operations for the Riot organization. I'm super excited to have you here with us today for Riot's Lunch and Learn series. This is an opportunity for us to showcase our sponsor network, and I'm super excited to have John Sotomayor here with us today, founder and principal of SotoIP. SotoIP has been a longtime supporter of the Riot organization. John teaches workshops in our Riot Accelerator program. He's given several different lunch and learns on a variety of different topics, and I think you're really going to enjoy his session that he has prepared for us today. A couple quick housekeeping reminders before we get started. This session is being recorded and will be posted to Riot's YouTube channel and then shared to Meetup where you can watch it later. And if you have any questions throughout the presentation, I encourage you to use the chat box. We will make sure that John answers all of your questions after the presentation. John has already provided his contact information up here. He will not be using a lot of slides as his presentation is just that phenomenal. You'll wait and see. But that is the best way to contact him. But of course, if you want to have any help contacting him after, I'm more than happy to do that. Without further ado, I know you are all here to see John, so I will hand it over to him. Thank you for being with us today.
Thank you very much, Carolyn. I have to say that Carolyn is far more photogenic than I am, but hopefully the information that I have for everyone today will help make up for that lack. First of all, I want to give a little bit of background information on myself, about 30 seconds worth of information that'll help you understand a little bit more about me. Started my career with a degree in electrical and computer engineering. Spent 18 years as a software developer manager before switching over to working at the patent office as a patent examiner. After 4 years there, even though I was a senior level examiner, I decided I wanted to continue my legal education by going to law school. And upon graduation from law school, joined a startup company, startup software company as in-house counsel. When that company was acquired by a much larger organization, my partner and I started SotoIP in 2014 to help strategically inventors, startup companies, and emerging growth companies with their informational needs with regard to intellectual property. And that leads right into exactly what I'd like to talk with you about today. Strategically, we've had a lot of questions about why should an inventor or a small company, especially startup companies where money is very, very tight, usually very important to extend it as long as possible, why should you bother protecting your intellectual property in a new product or service? And by a new product or service, I use those terms specifically, because a lot of the things that we do deal with software systems, hardware systems and software systems combined, networked systems. We've gotten patents for companies using blockchain, Bitcoin solutions, all sorts of software solutions. So software can be offered either as a product or a service. And both are patent eligible with the right discussion and disclosure for the intellectual property. Regardless, intellectual property really covers all of the innovations that an inventor or a company has created in order to put their product or service out in the marketplace. And the US Constitution provides specific protection for inventors and writers to protect for a limited time their interests in their writings and inventions, to provide them the ability to profit from their writings and innovations. So strategically, why should you do this, given the fact that sometimes it takes quite a while to really fully secure your intellectual property? Now, intellectual property covers patents, copyrights, trademarks, and trade secrets. We're going to concentrate mostly on patents because that's what we do, and patents have the largest or the strongest area of protection with regard to intellectual property. Patents can take, seriously, years to go from filing before the patent is finally enforceable. that's been granted by the Patent Office and is enforceable. The thing to recognize is that patents are enforceable all the way back to the date of filing. So once you file your patent application, you're under patent pending protection, which gives you the protection that you need to move forward in the marketplace. But again, the question becomes, okay, it takes sometimes years to do this, and it's not inexpensive. So why should I do this as a startup company? Well, we'd like to focus your attention on 3 different areas for strategically why this should be done. The first is that when you have a protection for a service or product under an allowed patent, you have the ability to protect against competitors coming in and using your innovation without your permission. And you also have a stake in a position within the marketplace, because a patent is the right to keep others from making, using, selling, or importing your patented invention. Again, so a lot of times the question comes, okay, well, why? Well, we had that question from one company that we've been representing for several years now. They had a product called the NEGG. It's spelled N-E-G-G, and it is a personal egg peeler. And they first came to us with the idea of improving on how you can peel a hard-boiled egg. You can find the product out on various websites for sale, including Amazon, eBay, and other sites, the Home Shopping Network. But the NEGG started out as just an idea of an improvement for how people could peel a boiled egg. Well, when we first filed the patent application, the inventors at that time had a small company that they were just launching. And of course, like every small company, money was tight, but they made the decision that this was something that they wanted to make sure that nobody else could just simply copy and knock off. And this actually turned out to be a wise decision for them, because they started their fundraising efforts on a Kickstarter campaign. And as part of that Kickstarter campaign, they put all of their information about the device on their website. Well, while the patent application was wending its way through the patent office, 3 different companies overseas, 2 Chinese and 1 Taiwanese company, all started creating and producing knockoffs. They were actually selling knockoffs of this product in the US market, and through Craigslist and through eBay and through other sites at the same time as our clients were actually selling the product as well. Now, the knockoffs were made in an inferior fashion. Many of them leaked. They were just an inferior product all the way around, and they cost half as much as what the real product costs. While they were selling these knockoffs in the United States, however, the patent for their product, the NEGG, was granted by the US Patent Office. And this permitted our clients to go ahead and engage a litigation firm that contacted Amazon and eBay and all of the other internet service providers who had home shopping sites to have them take those knockoff pages down off their websites. And it permitted them to stop any importation of these knockoff goods at the border. So that provided them not only a position in the marketplace from which they could profit, but also provided them the ability to keep others out of their market space. And I have it on good authority, talking with the inventors, that they went from selling about 500 a month to selling 75,000 in 6 months once they were able to keep the knockoffs out of the marketplace here in the United States. So you can see that the first leg of strategy, when you're talking about protecting your innovation utilizing a patent, is simply that, protection. making sure that you can keep others from using or selling your product in the United States, and making sure that you have a position in the marketplace from which you can profit from the innovation. Strategically, the second point that we'd like to make in terms of why you should protect yourself with regard to a patent is by virtue of the fact that you have protection, you can increase the value of your company in terms of going after investment, or in terms of some sort of a liquidity event, such that so as to provide a greater valuation for your firm if you are selling the firm, or if you're going to be involved in an IPO or some other liquidity event wherein the company changes control. And this increase in value from being able to protect your innovations is very, very important. As I said, when I finished law school and was hired by a small firm, a startup firm, as in-house counsel, one of my tasks was to take the existing patent portfolio and increase it. So we increased the patent portfolio in this company. It's called Digital Smiths. They were acquired in 2014 by TiVo. And what we did when I was in-house counsel is we took their existing portfolio of 8 patents and increased it to 23 patents over a 3-year time period. Because Digital Smiths engineers and inventors were very, very creative. So based upon the strength of the patent portfolio, the owners and investors in Digital Smiths were able to receive a valuation that was twice what they had originally thought that the company was valued at. So they increased the value of their company by 100% through the virtue of having a protectable IP portfolio. And also, one of the things about the ability to increase the value is that a lot of times, if you're working with VCs or home offices or other vending or investing organizations, what they're going to look at is to see if you have taken a position where you are protecting your intellectual property, because they also know that if you can protect your position in the marketplace, then the value of their investment goes up when they make an investment in your firm, simply by virtue of the fact that you do have that stake in the sand, so to speak, for your position in the marketplace, and that you can keep others from competing with you in that market space. So from the standpoint of the investment community, if you have protected your intellectual property, especially through patents, but also this applies to a lesser extent to trademarks and copyrights. Once you have done that, then the VCs not only see that you're serious, but also they will internally think that your valuation for your firm that they have in mind is higher than what it would be without you having sought for protection for your IP. So simply from a valuation standpoint, not only do we see things like, as I said, Digital Smiths doubling the value that they got for the company when they sold it, but also you get a higher valuation for your company if investing organizations see that you've taken steps to protect your intellectual property. And please remember that when you have actually filed for a patent application or for a patent, as I said earlier, the moment that you file a patent application, you're actually under patent pending protection, as I said earlier. And that will provide you with the ability to tell investing organizations, hey, we have protection all the way back to such and such a date, which is the date upon which we filed our first patent application. Also, though, there's the idea of monetization. What can you do to monetize assets. And in this case, a patent application or a trademark also provide you with assets upon which you can place some sort of value, such that you can engage in licensing contracts, or you can engage in sales contracts in order to generate income from these intellectual property assets. But strategically, there's another issue in terms of monetization, and that's the ability for an inventor or a small company to increase the size of the patent portfolio or trademarks for that matter. But patent portfolios are by far the most valuable. But you can also increase the size of your portfolio such that your monetization efforts can include not only seeking license fees from letting others use some of your patents, seeking the sale of some of these patent properties, but also seeking greater and greater positions in contract negotiations when you're moving forward with having somebody access your technology. One of our clients uses that exact strategy. We started working with a company called RideFlag in 2017, and they had created a technology, and we can talk about it because it's been patented. In fact, their portfolio spans half a dozen patents at this point in time. But they have created a technology that permits large transportation operators, those who operate HOV lanes and the other types of high occupancy lanes for highways on which people need to pay to access. So these companies who operate these transportation systems are looking for ways to verify that the individuals who are in HOV lanes actually are qualified to be in that lane because they meet, whatever the occupancy requirement is. When I was working at the patent office, I was living in Washington, D.C., and one of the biggest problems they had there was, again, making sure that the individuals in the HOV lanes actually had enough people in the car to qualify to be in that lane, because the cost of being in the HOV lane was oftentimes less than, or for higher occupancy, was less than for just a single individual. So if somebody was in the HOV lane and they didn't have the appropriate number of individuals in the car, then the transportation company was oftentimes missing out on revenue. I'll never forget one gentleman was stopped by a state patrolman in an HOV lane, and for a week he'd had the same woman riding with him in an HOV2 lane, but the woman was actually a mannequin. And when the state trooper stopped him, he said, "Well, I've been driving this for. How did you know that this woman wasn't real?" And the trooper said, "Mister, let me tell you, I don't know any woman who wears the same outfit 7 days in a row." So that was one way in which the trooper was able to notice this. But if the man had been smart enough to change her outfit, it's unlikely that he would have gotten caught. So RideFlag started out with that in mind, saying, how can we ensure that we can validate the number of individuals that are actually in a vehicle in the HOV lanes, and make sure that they have started and stopped at particular points so that we can increase the revenue of these transportation operating companies. And they came up with an ingenious methodology where they can take a picture using a camera, and the camera can be part of your phone, it can be on a laptop, it can be on an iPad, it can be installed in the dash of the car. But you take an image of the occupants of the vehicle, and they can, through facial differentiation, see not only how many individuals are in the vehicle, but they can also verify that each individual is a human being, and the fact that they're all different human beings. And we started out with as I said, one patent application with this idea in mind, and we've expanded it to patents on the biometric information, patents on how they use rewards and incentives, and all of this, such that we've expanded the patent portfolio to 6 patents so far, with another 3 filings that are wending their way through the patent office.
Were those 6 patents all
Yeah.
from the same specification, or were they 6
Okay.
individual specifications?
There are 4 individual specifications, 2 of which are CIPs, and the other 4 are just original. So it's sort of a blend. Some of them are the same specification, but most are not. Again, because they're actually utilizing this to expand the patent portfolio into additional scope over the original patent application. But that was a very good question. Thank you for that. But the way that in which that this helps them in terms of monetization is that because they have protection for several different aspects of validation, they were able to qualify for a contract with the state of California, the Department of Transportation that handles the high occupancy routes between Sacramento and San Francisco. And they were awarded the contract, which is, I'm not sure what the final number is, but it's in the millions of dollars every year in terms of income generation, because it's founded upon the patent portfolio. So from the standpoint of why you should bother, I mean, it's a long-term kind of view. You have to be willing to understand that when you seek patent protection, especially for any sort of a system that is based around software or combination of software and hardware, that it will take years, sometimes 2, sometimes 3, sometimes longer. We have one client who was in prosecution for 4.5 years before we finally were successful in getting their patent granted. But the average is about 2.5 years from filing date before you have a patent or patents that are generated for your portfolio. So you have to be willing to understand that it's going to take that amount of time and that it's not inexpensive. I mean, we can talk offline about, the types of costs that are incurred, but I know that a patent requires 2 different stages. The first stage is drafting and filing your patent application. And the second stage is actually prosecuting it through the patent office when an examiner actually looks at it and gauges whether it is patentable or not. And the way that an examiner does that job is they look at the claims in the application and they look at everything else that is out there to see if the claims you have filed would infringe on anything that currently exists in the public domain. Again, once again, like I said earlier, because the patent is a monopoly, they cannot allow claims that are directed toward a product or service that's already available in the public domain. And so they look to make sure that the aspects of your invention that you consider distinctive and different truly are distinctive and different before they allow the claims in a patent application. And that's the job of an examiner, is to guard against infringement. So let me just wrap this up with one more statement. So strategically, the thing that I want you all to remember is that when you are moving forward with considering IP protection, specifically around patents, you want to remember that a patent provides you with protection. It provides you with the ability to monetize your assets, and it provides you with the ability to increase the valuation of your company. So when you're considering whether you wish to move forward or not, please remember those 3 aspects, because on balance, if it is something that will be easily copied, like the neg, you need to have protection in the marketplace to keep others from attacking your position and selling knockoffs. If it is something that you're betting the business on, that is innovative and sort of speculative, and you need to seek investment in order to complete your entry into the marketplace, you want to make sure that you can increase the valuation of your company with regard to investors so that they'll invest more in your company to provide you with the runway to get to profitability. And also think about how you could possibly utilize the monetization ability of your patents to both generate income and to provide you with the access to more lucrative contracts as you move forward. Well, that's what I have for you all today. I hope that you found it interesting. And at this point in time, I'd like to open it up for questions and see if there's any other information that I can provide for you that will help you all in making these decisions.
Thanks so
I have
much,
a question.
Sure.
Oh,
Yeah, please go ahead, Don. I was just going to say, if anyone has questions, please feel free to unmute yourself. That's great. Thank you.
yeah, thank you. I just had a question. Do you have to have a working model or prototype to apply for a patent for both hardware and software? If you have a sort of a concept of how something would work, you can kind of describe it to patent it. Do you have to have a working model or prototype?
You do not actually have to have a working model or prototype. The legal definition of a patent application is a constructive reduction to practice. That means that you have to be able to tell somebody how to recreate what you did with your innovative solution just from the text and the figures that you file in your patent application. So once you get to the point where you have a constructive reduction of practice, that means you know how to build it. And if you can tell others how to build it, somebody of the same level of skill as you can then take it and build it, like you could send it off to somebody and have them build it. That's the level of disclosure that you need in order to file a patent application.
Okay, great. Thank you.
You bet.
Great question, Don. Thanks for answering, John. We have a question here in the chat box from Charles. How much does a typical design patent cost in attorney and filing fees from raw idea to issue?
That's a really good question. It's going to be a very, very difficult question to answer from one standpoint. Remember, I said that there are two aspects to a patent application. That is preparation and filing, and then prosecution. Preparation and filing for a design application usually runs between $2,000 and $3,500, depending upon the complexity of the design. And the thing, though, I want you to remember about a design application is that it is wholly concerned with the look of the device or the design that you wish to patent. So if somebody changes any visual element, then that gets around your patent. So you have to be sure that you're not going to change your design before you actually file the design patent. Utility patents are wholly different. They're based on function and structure. In fact, I'll tell you, we have a client out of San Francisco, and they had created a device that was very similar in look to a British company's device. However, when it came time to actually distinguish between the two, the San Francisco company had created something that had 3 metallic bands on one end and a metallic tip on the other end, which was sufficient to get past the British company's design patent. So the first part, like I said, usually preparation is between $2,000 and $3,600, but prosecution is the part that's really difficult to gauge. An examiner is going to look at the claims, and in the case of a design patent, they're going to look at all the figures, and they're going to compare it against everything else that's out there. If they find something that's very similar, then they'll send something called an office action, to which you must respond. Responding to an office action for design patent is anywhere from $1,000 to $2,000 per response, and it can take multiple responses to get from filing to an allowed design patent. Typically, now we've done dozens and dozens of design patents, and typically it takes about 2 office actions to get to patentability from filing. So for a design patent, again, these are ballpark figures, so some some company or some firms are going to charge you more, some are going to charge you less, but you should expect 2,000 to 3,600 for preparation, and you should budget 2,000 to 4,000 for prosecution. And that'll give you a good ballpark, I think, on what it takes to get through the design patent process.
John, does your firm also connect inventors to like industrial designers or people that can actually do design work?
Yes, we actually have several companies with which we work. Now, our firm is based, our home office is in Raleigh, North Carolina. So we have several design firms in this area with which we have good relationships to whom we can refer you. We also have connections with a company in Connecticut that does design implementations, but the ones that I recommend most frequently are here in Raleigh, and they're very, very good.
Okay, great.
Super helpful. Thanks, Sean.
Mhm.
Any last questions? Must have given a very thorough presentation, John, as always.
Well, thank you. As always,
encourage-
Kevin, it's a lot of fun.
It is. Yeah, it's great to have you back, John. And for those listening, thanks so much. I encourage you to reach out to John if you do have any other questions that you think of afterwards. His contact information is on the screen. And again, this presentation was recorded, so you can go back and reference it. It'll be available on Riot's YouTube channel later today.
Carolyn, if I can make one last comment.
Absolutely.
If you also go out to our website, we have a number of informational videos that we have out there for your perusal and can help perhaps answer some questions as well.
That's fantastic. Thanks, John. All right, everyone. We appreciate you being with us today. Thanks as always, John. Great
Thank
presentation.
you. We'll talk to you soon.
Thanks. Bye.
Bye.
Yes, Don, I will send the link right now. Thanks for